Welcome to the Legal Insights with Mixon, Carroll, and Frazier.
Welcome to Legal Insights with Mixon, Carroll, and Frazier. We're here with Attorney James Carroll of Mixon, Carroll, and Frazier in Columbia, Louisiana. James handles labor and employment matters and represents clients in state and federal civil litigation. For decades, he has worked on disputes that range from workplace conflicts to serious civil cases, giving him a clear view on how these cases actually unfold in Louisiana courts. I'm Leann Lyon, and today we are talking about how employment disputes escalate in Louisiana workplaces. Hello again, James.
Hi, how are you today?
Let's start here. In your experience, where do most employment disputes in Louisiana actually begin?
Well, again, it's an employment dispute, so it begins in the workplace. And it's just like a divorce case. It's the supervisor and the employee or the two co-workers spend a lot of their time together. If you think about it, you spend 8 hours a day at work, you spend 8 hours a day at home, and you spend 8 hours a day at sleep. So you spend as much time at work, if not more, than you do in any other aspect of your life. So personality conflicts are generally, I think, one of the motivating, the major contentions in the workplace that result in litigation. That being said, some of this arises from the fact that employers are more focused on getting the widgets made, whatever that is for their business, and consider human resources to be something that is a second thought or an afterthought. That's unfortunate. Employees, when they are not treated as they think they should be treated, or are treated in contrary to how the law is established, results in conflicts that arise to the litigation level. That being said, that ignores, of course, violence in the workplace. That's pretty self-explanatory. But these things tend to escalate when employees aren't happy with the results that they receive at the hands of the employer. If the employer sometimes would just simply listen, then that tends to resolve a lot of the issues up front. Everybody knows they can't have all their problems fixed. But when they're totally ignored and treated as second-class citizens, then things begin to spiral out of control.
So, would you say it's mostly personality that causes the initial conflict?
It could be, and it could just be misunderstandings. It could be, as I said, lack of communication. But it could also be, I do a lot of sexual harassment work. It could just be predators that are in the workplace. No employer wants one there. All of them work, I think, diligently to keep that at a minimum, but you can't control human behavior. And, we are sexual creatures by nature, and it tends to come to the forefront, no matter how hard an employer may work against it. And then some employers, depending on the type of industry, have historically not paid attention to that. And it's gotten much, much better over the years, but it still exists out there. Not so much gender discrimination, but sexual harassment in its basic forms. It's getting better, but it's still, the whole Me Too movement shows that it still exists and it's still out there.
At what point does a workplace issue move from an internal problem to something that has real legal recourse?
Yeah, that's a good question. Obviously, every employer wants to have the opportunity to address the issue first internally. Some do an excellent job. Others don't do anything at all. And then I would say a good majority do something in between. Again, I think it comes down to just basic human respect. The more an employer treats their employees as they would like to be treated, they tend to have the better workforces. And you can deal with it that way. Unfortunately, as I've said many, many times, employment relationships are a lot like a husband-wife relationship. Well, they're great until they go sour. And when they go sour, sometimes it's impossible to overcome that negativity and that hurt and that anger and sometimes even the hate that comes in that relationship. It's a very, very emotional relationship. It's something that, employees have given maybe 5, 10, 15, 20 years of their lives to, only to find that they are not getting what they want or they need at the end of the relationship that results in miscommunication, hurt feelings, anger, and a trip to see me, the lawyer.
It's truly a strong analogy and not one that I've heard before. I appreciate that one. So, moving on, how do Louisiana employers sometimes make a situation worse without
Mm.
realizing it?
I think the best way that an employer can mess things up is to, I told you so. The retaliation aspect, well, gee, if you don't want to work here, then you need to move on and I'm going to make your life miserable. That kind of attitude, if never said, can still be felt. It still comes across in the way that supervisors and or coworkers treat employees. And I say supervisors a lot, or management. It's really, in my 35 years of experience, it's not just supervisors. It could be coworkers or even subordinates that are allowed to behave in a way that is inappropriate. This anger that tends to build when issues are not resolved can result in very harmful things said and done to employees. And in today's society, some people are just looking for a reason to file a lawsuit. And I mean, I represent both defendants, the employers, and the employees. And I have found over the years that employees are just as dangerous in the workplace as employers are. It is a relationship that has to be nurtured and not one that is allowed to fester. And certainly you don't want to make someone pay for what they did through retaliation. That is clearly illegal. And not just Louisiana, but every state has retaliation aspects.
And on the employee side, what situations tend to evolve into formal legal claims rather than just workplace disagreements?
Well, breach of contract. I mean, if you've got a senior employee who is working under a contract and the terms of the contract are not met, that's an easy one. Breach of the contract, you failure to pay. I can't tell you how many times employees come to see me that, well, gee, I never got paid overtime, or I was paid less than what I was promised. Wow, I had to work all these hours and was never paid because they considered me an executive, a professional, an administrator, an exempt employee under the Fair Labor Standards Act, when in fact I'm not. And get to examine it and look at the different, since 1936, there's a bunch of law in that area. You start looking at the cases and realize that, hey, look, the employee's right. They were not exempt and they should have been paid overtime, or vice versa. The employee's wrong and they were exempt. Um, those are, payday issues are a big area. Benefits are another issue. Um, Vacation pay, when you're terminated, are they entitled to vacation pay? These kinds of things can get very complicated. Another area that is greatly overlooked by employers is OSHA. Is the workplace safe? Is the standards, if you're a manufacturing facility or a construction company, is your employer out there following the mandates and keeping the workplace safe and abiding by all the rules? And there's a lot of them out there to follow, and it can get overwhelming. Is the employer staying on top of it? Is the employee being trained? Is the employee receiving the help they need to get the job done? These are all things that, if not properly handled, can escalate into lawsuits. Another area, and I've mentioned it several times here on this broadcast, is sexual harassment. It's an area that everyone is uncomfortable with. Nobody wants to talk about it. If it comes up, everybody wants to look the other way and go talk to somebody else about it. It needs to be front and center and addressed immediately, quickly, clearly, and transparently. I know transparency is overlooked, but this is an area, or overused. Transparency in sexual harassment cases is an absolute necessity, and failure of a company to do these kinds of things and to put it on the forefront and to address it up front will absolutely result in uncomfortable litigation.
So, how does state law and federal law intersect with Louisiana employment disputes?
That's another good question. The federal law came from that deals with employment issues, comes from the 1964 Civil Rights Act. So, as you can tell by the title, it's been around for 61 years. And the federal government was the leader in this area and really began the process on addressing these kinds of issues. Again, Title VII of the 1964 Civil Rights Act deals with race, color, national origin, sex, and religion. Those are the basic categories. And over the years, those federal courts have expanded those categories to include just about every facet of employment law or of the employment context. State law has struggled to keep up. And I believe now every state has adopted a version of Title VII. But state law goes further than federal law. Understand, federal law sets a minimum. State law can come along and set a higher. For example, California has a wage law that says you get overtime after 40 hours in a work week and after 8 hours in a work day. So you'd get overtime for the 9th and 10th hour, even if you don't exceed 40 hours in the work week. That's California. It provides a better benefit for the employee than, say, Louisiana. Louisiana mirrors the federal law and says you get 40 hours, you get overtime after 40 hours of worked time. So you can provide as the state the same that the federal government provides, or you can provide more. Louisiana, for its perspective, tends to provide the same that federal provides. And in some cases, they don't provide the same that federal provides. They provide either nothing and rely on the federal act, or they provide less. But state law has begun to catch up with federal law, and they work hand in hand. State law generally covers areas that federal law does not cover.
Can you share an example of a dispute that started small but escalated into litigation, and what changed along the way?
Yeah, that I don't want to take a lot of time with it, but early on in my career, there was a lady who was the company was a construction company, and they had a situation where an elder employee in his late 60s, early 70s was operating a piece of equipment and had an accident, and he was killed. And a couple of months later, another elderly employee, been there for 40 years, was operating a different piece of equipment, and there was an accident and was killed. So the president of the company said, we're going to solve this problem. Anyone over the age of 60 has to retire. As we're not going to discriminate against anybody. Everybody over the age of 60 has to retire. And the secretary for the company, who he himself was in his 70s, so he retired, and she had to retire as well under this new rule. She files an EEOC charge claiming that she's the victim of age discrimination, and she was. And once they called my law firm and retained us, we said, you can't do that. We'll reinstate everybody, because that's not what age discrimination is. You can apply it to everybody, but if you're over the age of 40, that's discrimination. You can't do that. So we brought her back. And when we brought her back to work, or made her the offer, she was like, no, I don't want to go back to work because I've been sexually harassed. And so that opened up a whole door to something else we weren't even anticipating about, didn't even know about. So, yeah, I mean, it can be, things can grow from things that you're not expecting. And, it's just human nature.
Wow, that is quite the story. And yeah, the twists and turns of everyday life, right? In law. Well, as we wrap up today's episode, when a business recognizes early warning signs of a serious dispute, what factors typically determine whether the issue can be resolved internally or is going to be heading towards court?
The easy answer to that is the attitude of management. If management is willing to talk, then generally that can be eliminated or reduced. And I know my comments always seem to be focused on management, but remember, management has the power. And the employee, in most cases, I've found, just simply want to be heard. They want to be listened to. They want to be acknowledged. And if that happens, then sometimes the course of future events are changed. There are, depending on the individual, some people who simply are not going to be happy no matter what you do, and they're not going to be satisfied. That being said, there are some grievances that are so strong that no matter how much the employer listens to them, they've still been wronged, and that some corrective action needs to take place, if not compensation, something else. And most employers dig their heels in after they stop listening and put their heels in and stop the grievance process or the attempts to solve things. Once you get to loggerheads, then litigation generally follows.
I'm going to ask one more quick follow up to that. At what point should somebody who feels like they are, potentially involved in an employment dispute, at what point should they talk to somebody?
I would think they should, in my opinion, they should talk to an attorney as soon as possible. You need to know what your rights are. I've been surprised over the years how much of a misconception people have as to what their rights are. I have a large number of people who come through my office wanting to engage in litigation because they've been wronged, and they simply haven't been illegally treated. They've been treated wrong. They've been treated unfairly. They've been treated badly in their mind, and maybe even in my mind, but they haven't been treated illegally. And there's a definite distinction between an employer who's a bad employer or a supervisor who's a bad supervisor or a bad set of facts at the workplace that do not rise to the level of illegal activity. And that's a distinction that, is difficult at times for an employee or a worker to understand. And that's where legal counsel comes in helpful for guidance.
And with that, that is the conclusion of today's episode of Legal Insights with Mixon, Carroll and Frazier. If you'd like to learn more about James Carroll and the team at Mixon, Carroll and Frazier, you can visit mixoncarroll.com. There you'll find information about their work in labor and employment law and state and federal civil litigation across Louisiana. Thanks for listening. Be sure to like, leave a review, and subscribe to the show so you catch every episode. Thank you, James.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.